Thanks. Yeah, the next talk will be, okay, that's again cancelled, on EU-EPLA and community patents, software patents reloaded.
Do you know, put it full screen?
This one, full screen. No.
Full screen.
Full screen. Anyone knows how to put that full screen? There's no full screen.
Sure.
On the what?
No, full screen. Normally it's F11 on
No. There's no full screen. No, start your talk.
Okay, thanks.
Hello, hello. Okay. My name is Benjamin Henrion. I work for FFI Brussels, the Foundation for Free Information Infrastructure. And our association has been created in 1999, and we have been fighting software patents since then. I've somehow started the Euro-Linux petition in 2000. Maybe some of you have signed it. And we somehow managed to get enough trouble for the software patent directive that was rejected by the European Parliament on the 6th of July 2005, which was 2 years ago. And 2 days before the vote, the pro-patent camp, which was mainly the BSA and ECTA, which regroups Philips, Ericsson, Alcatel, and so on, called some MEPs in the right-wing part of the European Parliament to ask to reject the directive, which is somehow uncommon for a second reading of a European proposal. And they asked for rejection of the directive because they feared that our amendments, which were against software patents, had somehow a majority in the European Parliament. And they said, at least at that time, they said that they could get software patents through another way in Europe. And some of the MEPs, like Alan McCarthy from UK, said on her blog or website at that time that they would reopen the issue with the community patent. At that time, I didn't understand what it was about, and I didn't saw how you could change the legal situation in Europe with this community patent, which doesn't touch what is patentable and what is not. And the whole trick right now is to say we have the European Patent Convention, which says that computer programs are excluded from the field of patentability, and the next article says that they are excluded as such. And the European Patent Office interprets these terms as being if you claim in your patent that it's somehow implemented in software, they will probably reject it. But if you claim a machine that has certain features implemented in software, then they will grant you the patent. So, and this was the case in the last Amazon one-click patent that has been rejected some weeks ago by the EPO. And one of the examiners said, yeah, somehow this trick is well known by all the patent attorneys, and that's the way they get software patents in Europe. Now the situation is that for all 32 members of the European Patent Convention, which is an intergovernmental convention signed by most European member states, that you have centralization of granting of patents. So if I want a patent for France, can go to the EPO and have a patent for France without going to the French patent office. So the granting side is centralized. Now the post-granting side, which is the court, is left to the member states. So when you have somehow to attack a patent when it's granted by the European Patent Office, you have to go in several member states where it's delivered in front of each court to either cancel it or fight against it. And the idea is that since I think it was in the end of the 60s, was to create a central court for patents in order to get one patent, one ruling. And so there is, the EPO was doing lobbying somehow in the European Parliament in 2005, and one of the lobbyists who left his job at the European Patent Office as a representative in Brussels said the acrimonious debate over the proposed directive on computer implemented inventions might never have arisen if the patent litigation system in Europe had been unified, thereby eliminating the possibility of disparate national rulings on the same patent matter. So it means that the centralization of especially validity, because what the patent people wants, the patent establishment wants, is to create a central patent court for validity. So it means if our association wants to go to this court and say the law is exclusive of the patents and this patent should be rejected, the court will say, oh, well, we know about this story, we interpret the law this way, and we follow the case law of the EPO. So the result of this centralization of the court system can be the same as the directive on software patents, which would legalize the thing, but it will legalize it by case law and centrally all over Europe. And that's basically the danger. Right now it can be really worse because in terms of damages, when you go, right now the litigation is country by country, so when you go to litigate against an opponent in France, the judge will award the damages for France. But when you have this court system which is centralized, the court will calculate the damages over bigger markets. So if your company is somehow affected by this software patent issue, where the damages are calculated in number of copies of the software distributed, the consequences for your company can be even worse. So now you have this project of signing the European Patent Litigation Agreement, which was international treaty project similar to the European Patent Convention, but somehow it conflicts with the EU system, which are the 27 member states. So right now the idea is to get the same system, the same proposal as this EPLA, but somehow in the EU framework. And this, when it comes to those kind of decisions requires unanimity in the Council. So if the Council managed to get no veto rights from Poland or some countries that doesn't want this centralization, they get a central court in Europe. Now this will change with the new Lisbon Treaty because the whole voting system will switch from unanimity to qualified majority, which requires 66% of member states to pass a decision. And so what will happen in the near future is that the Slovenian presidency and the French presidency will try to push for having a central court for patents and the community patent, which is somehow where some delegations want still to have this central court, which is below the European Court of Justice, competent for both for European patents, which are not community titles, and also the future community patent, which is one patent granted for all the 27 member states. Yeah, so I finished. Basically, right now the fight, why it's not progressing, is because there is a fight between people who want to separate validity and infringement. And for example, when a company accuses me of patent infringement, I counterclaim that the patent is not valid. So, and somehow this issue about infringement and validity is there for 40 years. So it means that somehow this issue is old, and maybe they won't manage to get any political decision. So right now that is the status, and